Delving into the concept of the Immutable Triad reveals the foundational principle upon which democratic governance stands, the separation of powers. This legal and historical analysis aims to explore the origins, significance, and enduring relevance of the separation of powers doctrine in democratic societies. Dating back to the Enlightenment era and championed by political philosophers such as Montesquieu, the separation of powers serves as a cornerstone of modern constitutional systems, ensuring a system of checks and balances among the executive, legislative, and judicial branches of government. The concept of the separation of powers stands as an enduring testament to the essence of democratic governance, embodying the idea that no single authority should wield unchecked control. Rooted in the philosophical musings of luminaries such as Montesquieu and bolstered by legal doctrines, the separation of powers is the bedrock of modern democracies. I. Historical and philosophical underpinnings. A. Montesquieu's Enlightenment. Ideals. The notion of the separation of powers finds its roots in the Enlightenment philosophy of Charles-Louis de Secondat, Baron de la Brede et de Montesquieu. His seminal work, The Spirit of the Laws, 1748, profoundly influenced political thought and governance structures. Montesquieu advocated for a clear division of powers to prevent tyranny, stating, "When the legislative and executive powers are united in the same person or body, there can be no liberty." B. John Locke's influence. John Locke, another influential Enlightenment thinker, contended that the separation of powers is essential for safeguarding individual liberties. In his Second Treatise of Government, 1689, Locke asserted, "The legislative cannot transfer the power of making laws to any other hands. And when the people have said, 'We will submit to rules and be governed by laws made by such men and in such forms,' nobody else can say other men shall make laws for them." 2. Legal foundations. A. Constitutional safeguards. United States. In the United States, the separation of powers is enshrined in the Constitution. The framers, influenced by Montesquieu, devised a system where the legislative, executive, and judicial branches operate independently. As James Madison, one of the architects of the U.S. Constitution, wrote in the Federalist Papers, "The accumulation of all powers, legislative, executive, and judiciary in the same hands, whether of one, a few, or many, and whether hereditary, self-appointed, or elective, may justly be pronounced the very definition of tyranny." United Kingdom. While the United Kingdom lacks a written constitution, the principles of the separation of powers are embedded in its constitutional framework. The judiciary remains distinct from the executive and legislative branches, ensuring a system of checks and balances. B. International recognition. The Universal Declaration of Human Rights, UDHR, and the International Covenant on Civil and Political Rights, ICCPR, recognize the importance of separation of powers in safeguarding human rights. As stated in the ICCPR, in the determination of any criminal charge against him, everyone shall be entitled to a fair and public hearing by a competent, independent, and impartial tribunal established by law.